Hi there, and thanks for joining us once again. As part of our series of interviewing top lawyers across the country, we are pleased once again to talk with Brian McNamara. Hey, Brian.
Hi, Victor. How are you?
I'm doing great. Thank you so much once again for joining us for this discussion centering around high net worth divorce.
Happy to do it. Thanks for inviting me.
So let's get into your bio just a little bit. We'll tell folks a little bit about yourself. Brian's been practicing in Texas for 30 plus years, and he's handled countless family law matters involving estates of all sizes and pretty much every issue you can imagine. And one thing that's great about Brian is not only is he very experienced, but he also has a great online reputation with 5 stars on Google and Avo. So, once again, welcome, Brian. We're going to be talking a little bit about high net worth divorce and property division. So, for the viewers, would you like to just touch on what high net worth is? There's probably a threshold or a bar there that becomes high net worth divorce. Could you touch on that a little bit?
And that's really relative. It really is to where you live, um, because it has to do with standard of living and cost of living. Obviously, high net worth in Beverly Hills is way more than high net worth in a small town. So it really depends more on where you live in terms of cost of living and standard of living. But it does have to do with having. There's no I'm not aware of a firm number, but it has to do with excess wealth, and I don't want to say excess wealth, excess funds. So it's people who are not just comfortable, but they have plenty of excess funds to do what they wish to do when they want to do it, and meeting all the basic living expenses is long behind them. In terms of a number, it's really hard to say because it's like I said, it's all relative. It'd probably be at least a couple $1 million, but it could be. But in some parts of the country, that doesn't even buy you a house. In most parts of Texas, it buys a nice house. So it really depends. But by and large, it's people who either have their own business or they're A-level execs. Pretty much would be who you'd be looking at the high net worth.
Right. And it might also be reflective of a variety of different asset types, right? So, Texas community property state. So, assets, debts, and liabilities are all part of the community estate. High net worth divorce might involve lots of different asset types, right?
Oh, absolutely, it could. Certainly. I mean, it doesn't have to, right? I mean, someone could have a business that they've built that's worth a lot of money, and that's it. They got everything's paid for. The house is paid for. They got some nice cars that they like to drive. Maybe they got a couple of boats or a boat or whatever. Take nice trips, have a very comfortable life, but yet the assets may be diversified, may not. It could be a business. They could have made money from the business and taken that to diversify into other assets, whether they're liquid investments, not liquid investment, but investment funds, liquid cash, or real estate, art, who knows? So it's not necessarily a lot of different diversified assets, but it certainly could be.
And certainly, there's just a complexity factor there that's probably involved, whether it's just a business or if it's a multitude of different asset types. So, you're talking about complex situations. And those divorces may involve a variety of different parties like accountants, tax attorneys, business valuators. So, how does your role change a little bit when you're involved in more of a high net worth divorce situation?
Sure, sure. That's a very good question. And it depends again on what the assets are, but by and large, it's one finding the assets. We have to make sure we find everything, that we know what they are, and then finding the right people to assist us if we need assistance. So if it's a business that has to be evaluated, finding the right kind of person who can do that valuation for the business. Make sure it's someone who knows how to do a business evaluation in the context of a divorce. Because, for example, there's certain things that happen in the sale of a business that are not taken into account necessarily in the context of a divorce. It's the fair market value of the business, but a purchaser of a business will often make it conditional on the seller signing a non-compete agreement. Well, one of the presumptions in valuing it for a family law case is, or a divorce, is that there is no such non-compete. So, is it a business that is built entirely on one person, or is it a business that's got a brand name? Because you don't want that affects it. Likewise, the buyer will sometimes make it a condition of the sale that the seller stay on board for 6 months, a year, 2 years to introduce the employees to the new people, maybe introduce the customers to the new people. We also do not make that presumption or assumption when valuing it for divorce. So it has to be someone who knows how to do it how to come up with the fair market value. Without implying assumptions that are not appropriate. So that would be in the context of a business, in the context of retirement plans. Some of them are basic ERISA plans. They're not complicated. Well, they can be, but once you know how ERISA works, it's pretty simple. But sometimes executives have plans that are not ERISA qualified. They're very different. They can be cliff vesting, and if you don't write the agreement right, a whole lot of money can go in the wrong direction. Depends which side you're on. A whole lot of money that's available from a cliff vest that was earned during the marriage might not be received by the other spouse because they didn't know about it. Sometimes those plans are administered by a different department. So a subpoena to the HR department might not reveal all of the executive level plans. So in terms of how we work, it depends on what the assets are, but it does often involve making sure we get the right people who can help us as needed. A forensic accountant versus a regular accountant, regular CPA. And like I said, a business evaluator who knows about divorce. So those are the kind of things that we have to look at sometimes. And then sometimes, if there's assets in another state or another country, we may need to involve a lawyer in that state or country to help us get information about them. Usually within the United States, we don't have to. We can usually get the information without having to have a lawyer. But in a foreign country, it can be absolutely a necessity.
Yeah, makes sense. And that was a good deep dive right there. Do you think you could talk a little bit about the beginning of the process, given some of the various asset types that we've talked about earlier? What are some of the options you can explore for dividing up the marital estate fairly? Like, do you get a whiteboard out and start listing out assets and start talking about, okay, who wants this, who wants that? Could you start at the beginning of that process?
Right. In any divorce, the first step is to stabilize the immediate situation, and that's a temporary order, and that's not exclusive to high net worth, but that basically says, if necessary, who's going to live in the house temporarily, when are each going to see the kids, how are the bills going to get paid, temporary stuff. Okay, get that under control. Often it's by agreement. Sometimes people don't even need a temporary order. They're working okay. They don't need a court order. As far as the estate, what we're trying to do is build what's called, in Texas, an inventory and appraisement. Different states have different names, but it's basically an inventory of all the assets that is owned by either spouse, whether separate or community. And it's not an inventory in the sense of a grocery store inventory. We don't need to list every knife and fork and spoon in the kitchen. We can say everything in the household, if sold at a estate sale, would be X dollars. And incidentally, in high net worth, they're estate sales. For everybody else, they're garage sales. But basically, we can put the household items in a separate category. Just here's what they're all worth if we sold them. Okay. But then we have to list everything. What is the retirement worth? What is the business worth, if there is one? What is the real estate worth? And so the first step is figuring out generally what does our client know that they have. sending questions to the other side, usually discovery requests. Sometimes the lawyers will agree to provide that stuff without difficulty, but we want to do it in form of a discovery, so we have a affidavit that it's accurate. And the goal is to build an accurate inventory and appraisement. And while that might sound simple, it often isn't. Sometimes we can agree on the house value. If there's a mortgage, okay, we know what the mortgage payoff is, we have the value. If we can't agree, well, it's going to have to be appraised. That's not a very involved process, getting a house appraisal, not compared to getting a business appraisal. Getting a business appraisal is a big deal. We also have to try to learn early on, are there out of state or out of country foreign assets that we need to start working on right away? Because at some point, the court's going to issue a scheduling order and they're going to tell us a trial date. And the majority of divorces are settled by an agreement somewhere along the way, but we never know for sure which ones it'll be. So we have to be prepared. So we have a certain amount of time within which to gather information. So we like to get started early, right away, getting what we need if there's, like I said, out of state or foreign information that needs to be acquired. If we need to get an expert on board, we need to get them working because they can be slow. I mean, everybody says lawyers are slow. Experts are busy. They take a while. So we get the expert, we send them the retainer, we send them the information, and we start bugging them for our report. So it's basically identifying what we know the assets are and how are we going to get information on accurate values for each of those assets, and then sending information questions and requests for documents to the other spouse, making sure that we know what all the assets are. And that's influenced greatly by who our client is in terms of who managed the finances. In many households, or many marriages, one spouse does most of that. It's not all. Sometimes it seems like it's more commonly the husband, but not always. Sometimes there's a lot of cases where guys are making really very high income. They're working, often on the road, and wife handles all, or other spouse really handles all the finances. And so sometimes it's one spouse, and sometimes it's a wife who's in my office saying, "I don't know what we have. I don't have a clue. We're going to have to find out." Sometimes it's the other way around. It's a husband who says, "I can find out what my 401k is, but but it's going to take a while to learn where everything is." Sometimes we issue a subpoena to a financial advisor or an accountant, but it's first step, in response to your question, first step is, what do we know there is? How are we going to find out what else there is? And how are we going to get values on all these things?
And for couples who've been married for many years or even decades, a big asset can be an inheritance, right? And sometimes those can be protected by prenups, but oftentimes if you didn't forecast this inheritance deep into the future, it's just something that happens over the course of our lives. Can you speak to high net worth divorce and inherited property and how one party may be able to protect that, or the other party may want to get a piece of that inheritance? How do you work through that process?
Well, so Texas law, at least within Texas, the law is pretty clear. Inheritance that is left to one spouse is separate property. It is not subject to division in the divorce. If it's left to both of them, well, then they have equal interests in the inherited property. But that's rare. It's rare that someone passes and says, "I leave to my child and their spouse the following." It's usually they're left to their child. So it's separate property. Where it can become an issue is where you can't find, if it's spent, it's gone. There's no accounts receivable and accounts payable in divorce. If it's spent, it's gone. If it can be traced to an existing asset, well, then that's still separate. So, for example, if someone inherited a bunch of money and they can show where they took that money and bought an apartment building with it, that apartment building is separate property, assuming they can show it, because the burden of proof is high. It's clear and convincing evidence, which is a high burden, but meetable. We deal with it, and we meet it, and we prove it, but it's just more than regular preponderance of the evidence. you can have problems where you can't discern the separate property anymore because it's so commingled.
Right.
They get it and they put it into a joint account with both names. Um, and they take money out and they put money in. And sometimes you have to get an accountant. And there's rules in Texas with that. One of them is community out first. So if you inherit $500,000 and you put another 200,000 on top of it by depositing paychecks, which are community funds, and then through the course of the marriage you make total withdrawals of 300,000. Well, then only 400 of the separate property remains. Once it's gone, it cannot be replenished with community funds. It's gone. It's gone. So there are rules for dealing with it, and usually it involves an accountant. But the first rule is inherited property is separate property, and that can come as a surprise to people because I have had situations where two people are average wage earners, or they may even be good wage earners, but they're not really high net worth, and one of them inherited a lot, and throughout the marriage they've referred to it as their money and invested and acted as if it's their money. But then when divorce comes, the one who did not inherit it finds out it's not their money, it's the other spouse's money, and they don't have near what that person thought they did. That can happen, and that's just the application of the law. But if I'm representing the party who didn't inherit, then I'm going to hold the other one to the law and at least make them prove by clear and convincing evidence that it was inherited and how much of the inherited funds remain and how much has been and what was spent and is gone.
And if it's a considerable amount of money, let's say a person inherits $1 million or $5 million, that's when probably a postnuptial agreement might come into play at that point.
Yeah, it could, but the problem is you can't force someone to sign it. I mean, it's a negotiated deal. So the problem is, why would the other spouse sign it? I mean, there's reasons they would, but it's not in their financial interest to do so. Right. And they don't. And the other one doesn't need it. I mean, if you inherit money and you keep it separate and apart from the fund, from community funds in a separate investment fund, it's fine. It's inherited money. Some of it might be community because growth on separate is community. So if it earned dividends, if it earned interest, that could be community portion. But it's a lot easier to segregate that out, to calculate that, calculate it, but to determine what it is with a forensic accountant. They just go through the statements and subtract out the interest and dividends.
Like you said, sometimes it gets a little messy if it's an inheritance and the couple owns a restaurant that's doing so, and you eject money into the business, and then it becomes commingled. That happens.
Oh, that's that's like a law school question. Yeah, the money goes into the business, it's probably gone. I mean, there might be a reimbursement claim where the separate estate can request reimbursement of their funds back. It would just depend on the facts.
Yeah. So, and there are probably tax implications involved when dividing up some of these assets. So that's something you probably deal with, or you would bring in an accountant.
The first rule is that transfers in divorce have no tax effect. Okay, so if it's done right, okay, if it's done right, transfers in divorce have no tax effect. And what I mean by that is, you can take $1 million from a 401k and transfer it from one spouse to the other with zero withholding or taxes. But if you do it wrong, they're going to withhold 20%. Right? So you take $1 million out, you're going to get 800,000. They're going to withhold 20%. And then on top of that, when you do your taxes, you got to report it. Unless it's reinvested within 6 months, there's rules for that. But the way it's usually done is with a quadro, right? So when you do it right, there's no tax effect. However, depending on the asset, the basis goes with it. And I know that's, high net worth people will know what that means, right? But basically, whatever has been earned on that asset, that is taxable income on that asset, whenever it's cashed in, that goes with it to the person who gets it. Okay, so if you get a real estate investment with a low basis that has done really great, there's no tax on saying, okay, you're getting this $10 million apartment complex or $20 million apartment complex, whatever. But if the basis is really small, you're also getting the ultimate tax penalty that goes with that growth. Same with dividends, stocks, things like that.
And do you deal with that, or you bring in once again a team, right, of accountants?
Oh yeah. So if that's a question, yes, we will consult an accountant. Yes, if there's a question about, I mean, so we know that it's no immediate tax effect. So I don't need that. But where an accountant can come in is the post-divorce tax effect. So getting 100,000 of 401k is not the same tax-wise as getting 100,000 of cash. So in that respect, yes, we do tend to look at the taxes, because if you get 100,000 of, tax cash that you've already paid your income tax on when you got the money, there's no tax owed. If you get 100,000 401k, whenever you take that money out, you're going to owe tax on it. So that's why they're not equivalent. They're often treated equivalently because I think it gets complicated for some people to have to consider taxes, though Texas law allows us to consider taxes. And also some judges will say, well, that's too remote. These people in their 40s are not going to retire until they're almost 70. Nobody knows what the tax rates will be, so I'm just not going to take it into account. That can happen. But yes, where we bring in accountants is mostly for the tax effect of the division post-divorce. Who's getting more taxable money or assets, and what's the best way to offset it or deal with it. And that includes, of course, like I said, the basis on the assets.
Hey, Brian, so tell us a little bit why it's so important to have an experienced attorney uh, in high net worth divorce, somebody who's been through this before.
Well, now, one thing I was going to tell you, one, in response to your question, to know what to look for and to know when to bring in an expert to help do an evaluation. I've done many divorces where other lawyers missed things, often to my client's benefit. And, the nature of our adversarial legal system is not only am I not supposed to tell them, I can't tell them, hey, you're missing something. And that's not my job. It's actually contrary. It's a violation of my job. So knowing where to look and what questions to ask and how to evaluate things and how to get an expert are really important. So, for example, we have a statute in Texas that enables us to value the community portion of stock options and restricted stocks, stock performance units that companies sometimes issue. And people sometimes don't look for those. They don't realize the value of them. And it depends on the company. So it's important to look for those. So that's really the benefit of an experienced lawyer, is knowing what the assets are, what the statements mean, how to read the statements, how to read the basics of the tax return, and when you need to consult someone else, and when we need to look for additional information, and where to send the subpoenas. Right? And how to put it on an inventory and appraisement in a way that makes it easily readable to a judge or a mediator.
So going back to some assets, what about stock options? That is an asset that is of certain value now, right, Brian? And let me know if I'm wrong on this one. But in the future, when they vest in, let's say, 2 years, we don't know what the value could be. So how do you deal with a situation like that?
Well, okay. So, there's not as many stock options as there used to be, but there still are the restricted stocks, and there's still performance units that happen that get awarded. And the issue that arises under Texas law is that income, compensation during the marriage is community property. Compensation before or after the marriage is not. And so you can have restricted stocks that are awarded in tranches, and they may have a 5-year vesting period. And parties can be married for 3 of those 5 years. Someone may get 5 years of restricted stocks 2 years before they get married, or they may get them during the marriage, and 3 years into a 5-year vesting period, they get divorced. And so what we do, and most of those plans say that they cannot be divided, that they're not going to honor any kind of a court order that says give spouse X number. So what we have to do is we have to make the employee spouse a constructive trustee, which gives them fiduciary responsibilities, which means basically that they can be hit pretty hard in a lawsuit if you have to sue them for X number of the shares that are awarded to the former spouse. So to say, when they vest, sell them, or transfer them if you can. When they vest and become yours, transfer them to other spouse, former spouse. Now the issue is how many. What is the community portion? And for that we have a statute that basically takes into account the number of years married and the number of years that they take to vest. So the number of years married is a fraction of the number of years that they take to vest to come up with the marital portion or the community portion. So you could have 100 restricted stock units on a 5-year vesting period, and after 2 years, perhaps 40 of them are community property. So the employee spouse is court ordered that whenever they vest, if allowable, transfer half of the community portion stock shares to the other one. If they're not transferable, sell them and give the other spouse the money. And then we have to make allowance for tax provisions too. When we write that, we have to write, if they're going to be sold and you're going to give the other one the money, it's net of taxes. But so we are fortunate that we do have that statute that helps us value them.
Great information. Thanks, Brian. Beyond asset division, there are obvious other considerations in high net worth divorce, such as spousal support or child custody arrangements. How do you work with clients regarding that portion of a divorce?
So, yeah, Victor, before I answer that, my last answer, I just want to clarify one thing. I said the statute helps us value them. It doesn't. That was wrong. It helps us determine the community and separate property portions. Right? The market values them. They're worth what the market says they're worth. That's not what the statute does. It determines the community portion and the separate property portion. As far as spousal maintenance, right now the law in Texas still makes it difficult to qualify for spousal maintenance. Someone has to show that they are unable to meet their minimum reasonable needs. There's other requirements too, depending on how long they've been married, what they're entitled to, but basically that they're unable to meet their minimum reasonable needs. And that includes taking into account their earning ability, any separate property they may own, and their share of the community. So it originally passed in Texas, I don't remember, several years ago, as part of a welfare reform bill, so that people who were getting divorced and had no money and no means to earn money could at least get some minimum level of support if their spouse made at least a minimum level that could afford it. It is not for high net worth divorces because by and large, the share of the community estate awarded to the lower earning spouse is more than sufficient to meet their minimum reasonable needs. Minimum reasonable needs is pretty minimum. So, we do have situations where you have a high earner and they have not accumulated a whole lot. That happens. People can spend more than they earn, no matter how much they earn. And so, if someone finds out they're going to make $500,000, $500,000 a year, they think, wow, that's a huge amount of money. So they decide to spend $700,000 a year. It happens. So I have had circumstances where you have a high earner, not a lot of estate accumulated, in which case spousal support may be appropriate, where the lower earning spouse just needs some time and some help to get a job. Basically, sometimes they need 2 years worth of support to go get a certificate or training to do something in a field that they can earn money in. But it's not in any sense what people think of from the movies or maybe what some other states do, designed to keep someone in the same standard of living. It's designed to keep them off the street, basically. So with regard to child support, that is really not affected by the high net worth because in our state, it's a percentage of the payer's income up to a cap. The cap comes in at about 147, 48,000 a year, depending on whether someone is self-employed or not. The way we figure child support in Texas is we take the payer's net monthly income, which is not the same as adjusted gross income. It's everything they earn, everything, minus the required Social Security and withholding for one for one dependent, which is what they are, minus the cost of the child's health insurance if they're providing it, not both of them, just the child's. So there's very little deducted from their gross income. If that number is greater than $9,200 a month of net monthly income, the guidelines apply to the first $9,200 a month. So a net monthly income of $9,200 equates to an annual income of about $145 to $148, depending on whether someone is paying self-employment taxes. So under the guidelines, the maximum child support is $1,840 for one child, which is 20% of $9,200. It goes up in 5% increments, so 25% for two and 30% for three. And it goes up. The court can exceed the guidelines if the proven needs of the child merit it, but that is not easy to do. It's for circumstances where you have a special needs child who has a lot of expenses. And in that case, high net worth makes a difference because it's just a whole lot easier to order the parent to pay the money if they have the money. And then you could have instances where you have a child who is legitimately really good enough at some sport or music that they could be in the Olympics. And I mean, everybody thinks their kid's going to be in the Olympics. So that would require, testimony from either the parents could agree, or it would require testimony from a well-known and respected coach who could say, I've coached kids to the Olympics and this child is a real contender. Not, what everybody thinks about their own child, which is great. We should think it, but it doesn't mean they're all going to be there. Or they really have the talent to be a violin virtuoso with $1,000 a month of violin lessons. And fortunately, the parents can afford it. In that case, the judge could order it, but I have seen cases that are harsh, where someone makes a lot of money. Sports stars make lots of money, and they're paying $1,840 a month in child support in Texas because that's the guideline cap. So it doesn't typically have an impact. Sometimes the parents will agree to fund more into a 529 account for the for children's college. Sometimes the parent will voluntarily agree to pay more than the guidelines. The kids benefit in other ways because they're probably going to get a nicer, bigger house and probably better schools, just by nature of the parents having more resources.
Yeah, that makes sense. Parents, take care of your children.
Absolutely.
Well, Brian, over 30 years, I can tell you've worked a lot of different cases. You just touched on a few interesting things in the short video here with Family Lawyer Magazine. The purpose of these interviews are to help educate Texans about divorce and the process, and also showcase a little bit about yourself, Brian, and your law firm. So we're getting towards the end a little bit, but could you just briefly mention a few things that would set you apart as an attorney in dealing with high net worth divorce?
Oh, yeah, sure. Well, I've been doing this since 1992, and I've had all cases of all sizes, divorces of all sizes. I in the early part of my career, for about the first 15 years, I did a lot of civil litigation as well as family law. I've always done family law, but I did a lot of civil litigation. And that really assisted me because I find sometimes that lawyers who go straight into family law and only do that are not as well versed in litigation as lawyers who spent more time on the civil litigation side. Because unfortunately, it is litigation. Whether that's the best way to end a marriage is a separate question. But right now, we basically end a marriage in the same place where we do car wrecks and contracts with much the same rules of evidence and rules of procedure. Family code makes some changes, but in many respects, they're the same rules. And knowing those can really help. So my time in the civil litigation really did help a lot. And then having seen so many different types of cases really makes a big difference. Because ultimately, in family law, uh, our practice is very, very broad. We deal with everything a person could own. Eventually, anything that you can own is going to come up, and we deal with every single kind of debt you can have. Eventually, it's going to come up, and I think I've dealt with almost all of them. I'm sure there's some I haven't, but it's always interesting to learn something new. And then on top of that, we deal with children issues. So it's really broad, and I enjoy it, and I've learned a lot from doing it for many years. And I have a very good staff that I'm very proud of. And so, I believe we have a really good system in place to ensure that every stone is overturned, and we look beneath them, and we make sure we find what there is to divide up, and we get it properly valued, and counsel our client about making a fair and reasonable offer. And if we can't get there, well, then we'll go try the case. But we don't rush to try it right away, but we do prepare it for trial from day one. Preparing for trial from day one is undoubtedly the most effective way to get a really good settlement. And it sounds contrary, but the cases that go to trial are the ones where somebody's unprepared and the other side knows it, so they may as well go try it because they're not going to do a good job. When they know you're fully prepared for trial and you're ready to go, you have a much better chance of getting a very good deal. And if you don't, you're ready for trial. So that's kind of how we approach them.
Oh, excellent words, Brian. Thank you so much. We've been speaking to Brian McNamara, and if you're watching this video and seeking out divorce-related education, hopefully this has been helpful for you. And if you need further assistance and are considering a divorce, please do reach out to Brian and his firm, McNamara Law Office. He is highly recommended by Family Lawyer Magazine. Brian, thank you so much for your time today.
Thank you, Victor.